Pending is pending. Right.
Item number 1.
Yes,
May I please your lordship, my lord?
correct, Mr. Prakash, so yes.
Yes, my lord. This is an application under 482 in connection of a case, my lord. Itanagar PS case number 72 of 2000.
There was an arms recovered from your house. You have
That's right.
tried to cover it up by saying that it was given by the uncle of your
Yes,
wife.
Lord. And it was
This is from this is from Itanagar itself.
Itanagar itself.
You get your
CD.
CD.
Yes.
Huh?
Yes, Lordship.
When next week?
Lordship, in phase number 15, Lordship, in Excel 5, Lordship.
The earlier order.
Yeah, earlier, Lord.
I know, I've seen it.
That was fixed for hearing, but
But that
no,
is
no
a
record
different
was
case.
there.
That is a different case altogether.
Yes, Lordship.
Wherein he has been granted bail,
Yes.
right? So here what happened is the only incriminating circumstance against him is that when the police raided
Yes, Lordship.
his house,
Yes.
there was a gun,
Yes.
which is now connected with the proscribed organization,
Yes.
with an organization. But
Yes,
thing
Lordship.
is that the way he has described the raid,
Yes.
that the police went directly to that place, recovered that.
From his son, Lordship.
No, there is material. We'll have it on Wednesday. You
Yes.
get
My
your.
lord,
Yes.
lordship, kindly give us some interim protection, my lord.
Mr. Purkaisto, you are not here only. The client petitioner is not here. He is not come to what apprehension? He is in Delhi or at best in Guwahati. Affidavits have been sworn in Guwahati. We'll see the CD and pass the orders.
Then lordship fix the matter on 16th. I'm coming on 16th.
16.
Yes.
Okay. I can keep it next week also. You can do it online. Wednesday.
Yes, yes.
Yes.
Why
my lord.
until 16?
Yes.
I'll keep it on Wednesday. Wednesday.
Right.
Yes.
Heard Mr. A.K. Purkaisto, learned counsel appearing for the petitioner. Also heard Mr. D. Louis, learned additional public prosecutor. So issue notice. So the present application under section 482 BNSS 2023 has been instituted praying for pre-arrest bail. Has been instituted by the applicant praying for pre-arrest bail in connection with Itanagar Capital Complex PS case number 72/2025 under section 111 bracketed 2 bracketed B /3 /6 and 3 bracketed 5 BNS 2023 read with section 3 of the Unlawful Activities Prevention Act 1967 and sections 25 bracketed 1 bracketed 1B bracketed A bracket oblique 27 oblique bracketed 1 of the Arms Act. Also, Mr. Louis shall produce an updated copy of the scanned copy of the case diary in connection with the above noted case on the next date of district registry to list this matter again on. Yes.
My lord, may I renew my prayer for interim, my lord?
On 16, because of the incriminating material here, that's why I was a bit, and the case earlier also.
At
Just
least, my lord, I
withholding-
have. Right,
I'm
my lord.
withholding my hand. I'm withholding my hand, also noticing that you are not here. So there is no issue on 11/6/2020.
My lord, may I pray one more thing, my lord? If CD doesn't come on Wednesday, lordship will consider my prayer.
That you renew your prayer, we will be with you.
My lord, obliged. Obliged.
Declare.
Yes, Mr. Naba.
Yes,
Why are you going and making all this statement?
this is another case, this is a connected matter. This matter is connected with the criminal petition number 110.
110.
Yes, that may be, at least it says notice
Okay.
may be issued and matter may be clubbed together with 110.
Mr. Tapak, heard Mr. T. Tapak, learned counsel for the petition, also heard Mr. D. Louis, learned counsel appearing for the, a public prosecutor appearing for the respondent number 1. Also, issue notice. Also, as Mr. Puso, issue notice. petitioner to take steps for service of notice upon respondent number 2 by way of registered post to payee as well as usual process steps within 3 days. Also, registry to list this matter again after 4 weeks along with
This criminal petition number 110 of
Okay.
2025.
25.
Yes.
Criminal
One-
petition
110.
number 110
110,
oblique 20.
110. And over the interim order, notice will be issued. On the next.
Criminal petition. It's not a writ petition. We can
Uh,
anytime do that.
Yes.
Where is Mr. Pami? Mr. Pami, what is your instruction?
No show cause notice is issued.
No show cause notice. And what is the CCS prescribed rule you have quoted here?
The concerned official is also not sure, my lord, whether that will be applicable to him, my lord.
Okay. But this order is of 7/11/23.
Yes, sir.
So in the motion stage, will it be fair to set it aside? We'll note, we'll keep it for admission hearing and then finish it off. Otherwise, it may not. So already around more than 1.5 years. That justification of yours is not very. This order, Mr. Modi, was passed on 7/11. Your representation is of 26/1/24, 1 year, 6 months.
This, is still pending.
Forget it. Whether pendency of a representation will give you, extend your cause of action, no. Heard Mr. C. Modi, Learned Counsel for the petition. Oh, Modi, Learned Counsel for the petitioner. I can, Learned Counsel for the petition also heard Mr. L. Pami, Learned Standing Counsel,
2 to 5, my lord. Or 2
Power Department, no?
my lord.
Power Department. Full stop. Mr. Permit has on instruction submitted that that determination effected in respect of the petitioner hearing with regard to his casual service, while the communication dated 7/11/2023 was so done without issuance of any show cause notice and or giving an opportunity of hearing to the petitioner. Full stop. He submits that he would file an affidavit in the matter within, tell me, not much time. Don't take too much time. Just a small affidavit, this much. Otherwise, I can interfere it with today only, but I'm not doing it. When?
See, my lord,
Small affidavit, 2 pages.
yeah, my lord, the problem is, my lord, we need to rotate it to law department, my lord, after instruction from the concerned officer, my lord. With the mandatory.
Mr. Permit submits that he would receive written instructions from the concerned official and place the same before this court
My
on
lord,
the
that-
next date of listing. That will do. Registered to list this matter again on 16/6/2025. Full stop. On the next date of listing, the ऊपर में एक चीज लिखी issue notice, returnable issue notice. Full stop. Mr. Perme accepts notice on behalf of respondents number 2 to 5. And who is
2
appealing
to
for
4,
respondent
my
number 1?
2 to 5, my lord.
Mr. So-and-so, Learned Counsel, Learned Government Advocate appears for respondent number 1, and Mr. L. Perme, Learned Standing Counsel,
2 to 5.
Learned Standing Counsel, Power Department, appears for respondent number 2 to 5. Full stop. As all the respondents are represented, no formal notice is required to be sent. Full stop. However, requisite extra copies of the petition be furnished to the Learned Counsels representing the respondents by the Learned Counsel for the petitioner. Full stop. Registry, Mr. Perme submits that, written instructions, full stop. Registry to list this matter again on 16/6/2025, on which day an endeavor would be made to dispose of it.
High level.
So it balances out. Yes, Mr. Nabam.
Item number 4, I'm sorry, Malu, we have communicated, but instructions awaited. Now, in this count, your lordship can do 2 things, my lord. Either adjourn the matter or direct the, or direct the, my lord, the screen committee.
I can adjourn the matter, I'm not disposing it of, because it will again lead to a filing of a contempt by him.
My
It
lord,
will not give him relief.
absolutely,
We
my lord.
want the instructions.
My
When?
lord. my lord,
Monday, Thursday,
Monday,
Wednesday?
my lord.
Mr. Nawab.
Oh, sorry, I'm sorry, Wednesday I have some pro, Thursday,
Thursday.
no, I'm not-
Mr. Alex Nawab, learned additional advocate general submits that he be given a last opportunity to receive instructions with regard to the status of the inquiry undertaken by the SC/ST scrutiny committee with regard to the determination of the caste status of the petitioner herein. So, the prayer is not objected to by the learned counsel for the petitioner, Mr. M. Patil. Not objected to by Mr. M. Patil, learned counsel for the petitioner. So accordingly, raised it to list this matter again on Thursday would be 12/6/2025. However, it is to be noted that in the event the instructions are sought for are not placed on record, appropriate orders as would be mandated, including the direction for personal appearance of the officials concerned would be so considered to be issued by this court.
my lord.
Interesting order of the Supreme Court.
Yes, ma'am. But it was incumbent upon them, my lord, to press the matter, my lord, they didn't do it.
Neither did you do.
I was not required to, my lord.
Because you have the
yes, the
order.
beneficiary of the order of the.
Yes, madam. Now I think you will have to write a letter to the council there for a clarification. The intention of the Supreme Court is very clear. It says, forget this, wherever you are, proceed. That seems to be the idea amenity. But now you can take an advantage saying that the order is not implemented,
My lord,
not compliant,
my
not set aside.
my instructions, actually, when this IA was filed, to have this for post to spread in the field. My lord, we took a chance, my lord, saying that since it is now a selection post, there's nothing, there is the instruction, man. They ought to have, my lord, objected. In any case, there will have to be a seniority list, my lord. In the case of executive engineer also.
No, the seniority list was directed to be recasted by this court,
Yes,
by the appeal.
yes.
Then there was a status quo order. But Mr. D. Panik, learned counsel for the petitioner, and Mr. Pangu, learned government advocate, appearing for the state respondents. Also, issue notice. Also, Ms. Pangu accepts notice on behalf of the respondents number 1, 2, and 3. 1, 2, and 3. Also, no formal notice is required to be issued. However, requisite extra copies of the petition be furnished to the learned counsel, learned government advocate. Also, petitioner to take steps for service of notice upon the respondent number 4 by way of registered post with AD. Also, petitioner is also permitted to take service, to effect service upon the respondent number 4 by way of trustee note routed through the registry of this court. Also, in the event the service is soon effected upon the respondent number 4 by way of trustee note, the petitioner, after effecting such service, shall file an affidavit to that effect before this court. Also, registry to list this matters again after 4 weeks on a date. Hmm. What is there in this matter? What is there?
I am nowhere. Because
You are nowhere,
yes.
rightly so.
I'm nowhere. Even
Yeah,
after,
better.
even after getting.
You went somewhere uninvited or wrongly invited. And see the way they have intimated, intimation come apology letter.
Apology.
And still you are fighting against the government. After the government has apologized to you.
Kindly see the result notification. I am
Hmm.
the one who has been selected and she is the one who is.
Arre, that was a typographical error.
Then correct. Where is the correction?
Correction they have done.
No.
But they have informed this to you. See how humble they are. Please accept our sincerest apologies for any inconvenience that may have been inflicted on you, wherein we appreciate your humility in this matter and assure to that you acknowledge our mistake. Yes, sir, what is this? Yes, you are appearing.
Yes, standing counsel, T. Tagum is in court number 1.
Get Mr. Tabu. Get Mr. Pascal. And Mr. Saxena, you should not have filed this after this apology letter.
Wait, my lord, this is what is correct, my lord. Won't do it on Monday.
How do you do it here? After this correction, you file a fresh
I,
amended copy or
no, my lord,
a
we
that
have
page?
furnished the page, my lord.
Page,
the
okay.
list.
Also, the present interlocutory
Correct.
application has been filed in terms of the liberty granted by this court while order dated 35/2025 passing WPC number 231 bracketed AP of 2025. Also, the petitioner had instituted the connected writ petition being WPC number 335/2025. No, had instituted the connected writ petition being WPC number 231 bracketed AP oblique 2025 inter alia praying for consideration of his case for promotion to the rank of inter alia raising issues with regard to the promotion to the post of assistant, post of executive engineer. However, in the prior portion of the writ petition, more particularly in prayer B,
Yes.
C, prayer B and C, comma, bada bada, B bada, C bada, comma, such promotion was sought for to the post of apostrophe assistant engineer in lieu of the post of executive engineer. Full stop.
Interim post.
Further, in the interim prayer also. Similarly, in the interim prayer also, similarly in the interim prayer, so made also, the this court was required, a prayer was made to restrict the departmental promotion committee from considering promotion of the persons in the zone of consideration to the post of assistant engineer in lieu of executive engineer. Heard Mr. Formally, heard Mr. Deepani and also Madam. Madam, your name?
B Mema on behalf of Jita. B Mema,
On behalf of
Jita, standing.
B. Mema, Learned Counsel, appearing on behalf of Mr. Jeet Tara, Learned Standing Counsel, Rural Works Department.
Yes.
Rural Works Department. उसके बाद ये आएगा. Also, I have perused the contentions raised by the petitioner in the interlocutory application and find that the error so occasionally in the prior portion of the connected writ petition, comma, noticed here in above, comma, has been had so occasion on account of an inadvertent error. Also, the prayer made in the interlocutory application is not objected to by the learned counsel for the respondents. Also, accordingly, the petitioner is permitted to rectify, to correct the words, assistant engineer, apostrophe me, figuring in the prayer portion of the written petition, including the prayer for interim relief, comma, to that of executive engineer, apostrophe. Also, petitioner shall file rectified copies of the prayer portion, amended copies of the prayer portion in terms of the permission granted here in above, in terms of the order passed here in above. No, in terms of the permission granted here in above to effect the correction within a period of 3 days from today, 3 working days from today. So, full stop. The petitioner shall also correct the copies, advance copies given to the counsel for the response. So, with the above observations, the interlocutory application stands at disposal.
All right.
Dispose of the petitioner go order and fix it.
Not take much time.
No, you take your time, there is no problem. But before that, you tell me.
The fact was already directed.
No, forget the facts. There was a appeal filed by you. That appeal was remanded to the district authorities. He comes up before this court. This court interferes with that. Literally, the direction of this court is that the appeal has to be heard by the civil court. Correct. So, 138 was the appeal number. First question, why was it converted to appeal number 12? Why was the number changed?
Yes, because your lordship,
Because it was
The-
demanded back.
138 was registered at additional deputy commissioner here.
That order was set aside, so that 138 got revived.
Yes.
Who filed this 12?
On the direction of this honorable court.
No. Direction of the honorable court is to consider that appeal, not this. There was no direction to consider a fresh appeal.
No, learned court below was decided on that appeal only.
Where is that? Where is that appeal? Where is that renumbering order?
But appeal was renumbered.
Where? Where is that order? Where is that order? It seems to be a fresh appeal. This appeal was filed by the Mr. Tana.
Correct.
Where Mr. Tana, where is civil appeal 138, 2014?
We have not filed.
No, this
They have filed a 138 before.
138 was filed by you. And subsequently, I find from the records, 138 is no way. It is civil appeal number. You are Jumli Basa.
I am Jumli Basa.
Ah, so you are the appellant. It is 12 of 2022. What happened to 138? How did it become 12?
That, that part, I'm also not very clear as to how they landed the trial court. Well, that's, we will have the clarity from impugn order, whether can we come to 170?
And impugn order.
Yes.
Come. What is this judge writing? Huh? Come to page 2 of that impugn order, internal page 2.
Yes. Sri Jumli Basa.
No. Page 2, second paragraph.
Okay. Second paragraph. Under the aforesaid facts and circumstances, both the parties are confused as to who is appellant in this case. Although the owner.
Where is that occasion to draw this conclusion? This is contempt.
Perverse.
Your appeal was revived. What is this? What is this manner of recording?
Whether that, I apologize, I was not in the trial process.
And secondly,
Correct.
Mr. Tara, prior to passing of this order, there was an attempt made before the Luka order. Nothing happened.
Nothing else.
Then when the matter came back, there was a direction to the director of survey to carry out a survey of the land.
By these honorable judges.
Whoever it is, you both agreed to the report given by the director of land records. There were 3 plots. Plot number 1, 2, and 3. 1 and 2 or whatever it is, 2 plots, there was no dispute. 50-50, 2 plots, 1 for him, 1 for you. Dispute was with regard to 3. So he said that now this plot number 3, you divide it 50-50. Because you have already accepted that report. What is the error here? This is in terms of that.
It was prepared.
Kabang.
No, it was prepared in our absence. That is correct.
Accepted that.
No.
There is a, Mr. Tara, if I'm wrong, you just correct me. Come to page 108. 108.
108.
After this, what is left?
108.
8.
It is undisputed that the plot number 1 is.
No, 108. Both parties have submitted.
108.
8.
Both parties shall file their respective ordinance written this highlight the vital point favor in their sense.
The appellant is present along with learned counsel, Mr. K. Palm. The respondent is represented as A. Mansari. Both the parties have submitted that there is no issue with the survey report of the disputed land and 080623 along with maps so far. Their respective claim and counter claim over this state disputed land is concerned.
Thereafter, your appeal was dismissed.
Yes.
And then it was restored. And
No, then thereafter we went to the. We approached this.
no,
No, we
not
filed
approach, you
restoration.
filed an IA there.
Thereafter, we filed the restoration application.
Application,
that
it was restored.
was restored.
Now, what is the error here?
The error is,
You can't take up the plea of 151 here because this is your appeal. It's your appeal. You subjected yourself to that.
subjected, but procedural propriety is there.
What
I'll
procedure
come-
this is? Huh?
Well, I'm satisfied.
Hmm. Yes.
Here, my lord has already drawn the indulgence to page 118,
108,
118,
118.
118. There are 2, 3, 4.
Hmm.
It is undisputed that the plot number 1 is again divided into 3 plots by naming as plot number 2 as undisputed and plot number 3 and 4 as disputed. For that, my lord, kindly come to the main page. In our rejoinder, it is there. No, main.
Now, first you clarify
No, I'm
as to
just-
what has happened to
I'm
138.
Pardon me?
What has happened to 138? Come to the order of this book,
That is
the revision order.
the revision order is 85. 85.
You can come to page 87. 1, 2, 3, 4, 5, 6, 7 lines from there.
From the bottom. 7 lines from the bottom. my lord?
Bottom. Then being agreed, page 87.
Then being agreed by the decision of the Bangor level Sabha dated 16/6/2024, the petitioner, along with his mother, filed a civil appeal number 138 before the learned additional district and session judge Basar. But
So he had transferred it.
he has transferred to
Fine.
the additional.
Because of that, you have come back again.
We have come back.
Okay.
Because-
Now,
because
now
that-
you come to the operative portion.
The parties are directed. Well, before that, my lord, may I request to have a look at paragraph 11
Of this judgment.
of this judgment.
Okay,
page
come on.
92.
Hmm.
Here, my lord, the fact is given.
Okay, the case in hand, the dispute relates to so and so, so and so, so and so, as far as the so and so has been cultivating, then it's a proposal, so and so, so and so, so and so. So I think they have to be agreed by the decision, file a civil appeal number, so and so. Yeah, so and so, so and so, so and so. In view of the ratio laid down in the coordinate, in view of the fine solution around the same stands allowed, include order fine to so and so. In view of the judgment of the division bench of this court in so and so, and also the provision to section 2. So and so the matter is remanded to the court of the learned additional district judge, Assam. The parties are directed to appear before the court of learned district judge within a period of 15 days from the date of receipt of this copy. The judge on receipt of the order of this court, the learned session judge shall proceed to hear the matter in accordance with law. Okay.
Then,
Now the
then, my lord, may I request kindly indulge to para 12, page 93.
Hmm.
Page 93.
moreover the
In this, no, that's not, kindly, para 93 first, page 93, para, first para, bottom, my lord, 4 lines. Is without any jurisdiction part, Registrar General.
that is with regard to the order
Besides-
passed by the additional deputy commissioner.
This. There, the error committed by the additional deputy commissioner was no fair opportunity.
That is gone. That is gone.
Well, just
That is
coming, this has a correlation with the intent.
Hmm.
Besides, there is also allegation of violation of principle of natural justice. As allegedly, the deputy commissioner has not afforded opportunity of being heard to the petitioner and also to cross-examine the witness. Here, we know exactly why I have indulged my lord to this particular paragraph is that even if per se, my lord,
Mr. Tara, I get it. I get it. I have got what you want to
Because
say.
in the lower court below, there was no evidence, nothing was recorded.
I,
So therefore, the learned court below ought not to have invoked
Mr.
151 and
Tara,
not cross
Mr.
50.
Tara,
My lord,
first tell me, where is 138 now?
I am coming. Paragraph 13 is the answer, my lord.
And 13 is only to set aside.
Yes.
Have you filed a fresh appeal?
No,
Then,
that
if you have not filed a fresh appeal, how can this proceeding be held to be? How could this proceeding taken be? It will go in your favor. But I'll interfere with the order and say that the earlier order would hold the field. Because you have, in terms of the liberty given, you have not done anything. You have not filed an appeal. What happened to 138? Yes, Mr. Ansari. What happened to 138? Why did you all go and subject yourself there when there was no proceeding instituted?
Well, my younger says I should read out paragraph 13.
Appeal is not.
Okay, fine. We'll satisfy you. You read.
Appeal for personal injury.
In view of above, we find sufficient ground in the civil division petition and accordingly same stands allowed. The impugned order dated 06/2014 passed by additional deputy commissioner referring the matter to the Bangladesh Sabha and the impugned order dated 11/03/2020 passed by Lavin additional deputy commissioner deciding the dispute in favor of the respondent of which stands satisfied. Means appeal is still there. That appeal which we have filed remains alive.
That's what I'm saying. Where is that appeal? That appeal is no longer
Yes.
there.
Yes.
It is different.
Yes.
Your appeal is appeal
Then-
number 13, 130.
Then the fresh appeal we filed.
No, press appeal is irrelevant. Oh,
138 of 2014. Where is that appeal? This is an appeal of 12 of 22. How could this appeal be maintainable?
Well, just give me, just you have filed that.
Has a new appeal been filed?
No, 138 was registered before the deputy commissioner.
No, 138 is civil appeal before the court. It was transferred.
Transferred.
That was set aside by this court, along with the orders passed by the deputy commissioner.
Obliged,
So
obliged.
138, 2014 gets revived.
Revived.
Yeah.
So any proceeding will be taking place in one.
Page 37, Malad, kind of.
Huh? Page
37.
37.
Correct. This is the appeal which we have filed, 138.
138. So anything that has to take place will take place in 138 only.
Yes.
Will take place in 138. Till that time, the earlier orders will hold the field.
No, well, that is one apart. I just,
No, Mr. Tara, only satisfy me as to what is this 12 of 22. This court had not directed you to file a fresh appeal. Its order was in
Yes,
context of the
filing it.
earlier.
we have not filed it. It was just,
How?
they have,
Press appeal नहीं है.
this is not the fresh appeal. Under 46 minute only it was filed. The section 46 of the
No.
paper only filed.
Come
It's
to
registered-
page 95, that is the starting.
Well, from here, the thing
How
is.
can the new case be registered? It should be 138-14 only, which should be taken up for consideration. No other proceeding is permissible.
Your lots. Yeah.
Basar civil appeal.
Yes, Mr. Ansari.
When the appeal was registered before the additional strict court, it was registered at 138
Of 2014.
14. While it was transferred, being transferred before the deputy commissioner, it was re-registered. Your Honor. It can be transferred from the CRP page number 81.
81?
Page number 81, and it's a 10.
Okay.
And it's a 10.
Correct, my lord.
Here, case number Basar, it
my
was
friend is-
re-registered.
Where,
It is
where,
judgment
where,
of that
where,
appeal
where,
only.
where?
You know, on the right side of the top, case number Basar LK. This is the judgment.
Okay, that is different.
Yeah, they bring it.
This has been set aside.
Yes, Your Honor.
Yes.
So set aside means 138 proceedings,
Yes.
138 of 2014 gets revived.
This judgment was passed on that appeal only.
Fine, that is set aside. So
Yes.
the appeal gets revived.
Revived.
This judgment was set aside because on the ground that he does not have a jurisdiction. Right?
Correct.
So 138 gets revived. Why was 138 renumbered as 12 of 22?
12 of 20.
Record.
You'll have to clarify that. Both of you.
Record is.
Not you get me clarification, get me orders. Why should I call for the bulky record, spend the government money for your private dispute? When will you get that clarity?
My lord, this,
I can dismiss, I can allow the repetition, this criminal petition in 2 minutes, willing that the order passed this. That will not going to help you, either of you.
either of us, because
Again, there will be a marpit there.
They already encroached my land. They erected barbed wire. They're not allowing.
But the learned counsel for the parties. Also, in course of the hearing, it was revealed that with the interference made by this court of the order dated
I only gave the question of law.
11/3/2020 passed by the learned additional deputy commissioner Basar, the proceedings in civil appeal number 138 of 2014 instituted by the petitioner hearing before the learned additional district and session judge Basar was revived. However, it is seen that the present order impugned in the present proceeding was so passed by the learned additional district and session judge Basar in PSR oblique civil appeal -12 of 2022. So the parties have not, it is not clear as to why the fresh appeal case was required to be registered when the direction, when in terms of the directions passed by this court in CRP number, earlier CRP number,
CRP number 8 of 2020.
8 of 2020 had the effect of reviving the civil appeal number 138/2024. Also, the learned counsel for the parties on receiving instructions shall apprise this court on the next date of hearing as to why the fresh case being civil appeal number 12 of 2022 was required to be registered. That too without a fresh appeal being filed in the matter by either of the parties. Also, registry to list this matter again on when
26 of this.
26/6/2020.
My brother was there in the trial court. He's doing it.
No, you will have to clarify this. Otherwise, what will happen is we don't know what is happening. Or you will have to go back to the CRP court and get a clarification. Otherwise, 138 we revived, you pass order without appeal and with that observation that he does not know who is the appellant, who is the. You also made a submission that you don't know who is the appellant. He records that.
No, Your Honor. The Gaba decision was challenged by them.
No.
Therefore, they were the appellant, Your Honor.
In the order, it
Order,
says
it was
neither you nor he.
Yes.
it was
That is
recorded.
We'll take note of that
Interim continue.
in the next day.
My lord, what happens is, when people in the higher influence, they occupy those positions, we always, as a council, and we feel that the wisdom will fall from there. Because the larger wisdom always falls.
That's why I'm not proceeding. It may be a remark recorded without any application,
So, because sometimes.
without any meaning.
Well, why I have made this remark here. Sometimes people with a larger wisdom tends to commit mistake and fitting into the scheme of to err is human. So because they are also not fully equipped. Sometimes procedural error, these things happen.
Why should I say they make errors? We make errors sitting here. So who am I to say that they can't make errors?
With the gracious indulgence, whether kindly continue the entry pass earlier.
Interim order passed earlier to continue. But again, why should we continue that interim order when the proceeding is not there?
Otherwise, demarcation.
Yes, you tell me. Why should we continue with the interim?
Lordship, appellant, here in petitioner, Lordship. Petitioner filed the appeal. It's clear.
138.
Yes, Lordship.
But 138.
Never filed by the respondent.
138.
138. 130 is filed by the petitioner.
You just show me whether it is converted, re-registered.
No, Lordship. That record is not available. with us.
Get that.
That is.
Interim order passed earlier to continue till the next date of listening. This is for you, not for you.
Item number
Mr. Ansari, get it.
No, I
Okay.
request my brother Ansari to get that.
Otherwise, this matter again we'll have to interfere, it will go back. It will again delay. Yes. Such a good gesture from your part of issuing an apology letter, but he is again, see, questioning. Heard Mr. K. Saxena, Learned Counsel for the petitioner. Also heard Mr. K. Tavan, Learned Standing Counsel, Education Department, appearing for the, education or some,
All man, two, education matter is included.
Education Department, appearing for the respondents number
1, 2, 3, and 5,
1, 2, 3,
and 5.
4 also is the director.
4 is
4, 5. Also, also heard Mr. So-and-so, Learned Government Advocate, appearing for the respondent number 4. Also, the petitioner in the present proceeding has contended that in pursuance to her name figuring in the select list so published for the post of, what is FTT? Full-time teacher, bracketed English, on contractual basis. No,
Yes.
contract, full FTT, full-time teacher, bracketed English, with the Samagra Shiksha authorities, comma, she was issued with an order of engagement on contractual basis dated 8/3/2025. Also, the petitioner contends that she had joined the said post on 10/4/2025, has been working therein. Also, however, the respondent authorities write intimation come apology letter, apostrophe make up, dated 28/5/2025, had intimated the petitioner that her inclusion in the select list was on account of a typographical error, and actually it was the respondent number 6 on merits whose name ought to have been in, it is actually the respondent number 6 whose name was to be included in the said select list in terms of the merit position obtained by her in the connected selection process. Also, the petitioner submits that the said projection made in the intimation cum apology letter is erroneous inasmuch as the petitioner had secured a better merit position than the respondent number 6. Also, in view of the above, Mr. Tabam shall receive instructions with regard to the merit positions obtained by the petitioner and the respondent number 6 and place the same before this court on the next date of listing. Also, it is provided that in the event the post against which the petitioner was so appointed by the order dated 8/3/2025 is not filled up by issuing an order of appointment to the respondent number 6, comma, the respondent authorities till the next date of listing shall neither allow or shall not fill up the post in question by issuing an order of appointment to Ms. R to respondent number 6. So it is further provided that in the meanwhile, if the respondent number 6 has been issued with an appointment order, comma, the same would be subject to the further orders that would be passed by it.
Deeply ordered. After 4 weeks.
No. You get the instruction immediately. When? Only that much next week. Registrate to list this matter again on 11/6.
All right, man.
12/6, huh?
Okay. This is tape and every day.
Thank you. Thanks a lot to all of you. Bye.